Dr. V. Shanta, Chairman of the Cancer Institute, Dr. S.G. Ramanan, Dr. Vikash Maharajan, Dr. C.S. Pani, esteemed members of this Cancer Research and Relief Institute, dignitaries honored of the dais. I think I am the only odd man out. I am neither a doctor nor a caregiver, and at least not yet a patient. That is why you have had a very wonderful exposition about cancer from Dr. Shanta, and that has made my task more complicated because she explained in lucid terms as to what cancer is about and how one could prevent it. She talked about patients, and I have to talk about patents. The only difference between the two words is in the letter I. It is not without significance that this only difference between the two words is in the letter I. The letter I could signify inventors, investors, and the industry, which makes all the difference between a patent regime and a patient regime. Traditionally, ours is a country which did not believe in asserting intellectual property rights. In his immortal compilation of poems, Thirumandiram, Thirumular said, "நான் பெற்ற இன்பம் பெருக இவ்வையகம் வான் பற்றி நின்ற மறைப்பொருள் சொல்லிடின் ஊன் பற்றி நின்ற உணர்வுரு மந்திரம் தான் பற்ற பற்ற தலைப்படும் தானே." It means that the benefit of one's intellectual labor is to be used for the welfare of the society at large. Echoing the very same sentiments, Thiruvalluvar also said, தாம் இன்புறுவது உலகு இன்புறக் கண்டு காமொருவர் கற்றறிந்தார். According to Thiruvalluvar, the greatest incentive for a learned person is to know that his learning contributes to make the world very happy. This is why most of our proud products, the proud products of the Indian culture and the contribution of our ancestors to arts, literature, social and natural sciences and technology remained in anonymity. Therefore, the very concept of protection of intellectual properties, including patents, with a view to provide incentive to investors, appears to be alien to the Indian culture. Before we understand patent issues in cancer drugs, we must actually understand the origin and development of the patent regime in the whole world. Thomas Jefferson, who was the Secretary of State of the United States of America towards the end of the 18th century, was both an inventor and also a lawmaker. He is considered to be the first administrator of the patent regime, as he created the 1793 Patent Act for the United States. Like other Americans of those days, Thomas Jefferson also had an instinctive aversion to monopolies. According to Jefferson, the patent monopoly was not designed to secure to the inventor his natural rights in his discoveries. Rather, it was a reward, an inducement to bring forth new knowledge. The grant of an exclusive right to an invention was the creation of society at odds with the inherent free nature of disclosed ideas and was not freely given. Jefferson did not believe that the grant of patents for small details obvious improvements and frivolous devices would advance the cause of science and technology. The earliest patent laws to have appeared in the Indian horizon appears to be the Act 6 of 1856 for the protection of inventions based on the British Patent Law of 1852, which granted certain exclusive privileges for inventors for a period of 14 years. It was modified by Act 15 of 1859. Thereafter came the Patents and Designs Protection Act of 1872. It was followed by the Protection of Inventions Act of 1883 and then by the Inventions and Designs Act of 1888. Subsequently, the Indian Patents and Designs Act 1911 was enacted. Shortly after independence, a patent inquiry committee was constituted under the chairmanship of a person by name Justice Bakshi Tek Chand, a retired judge of the Lahore High Court, to undertake a comprehensive review of the 1911 Act. The committee submitted an interim report in 1949 and a final report in 1950 observing that the Act should contain clear indication that food and medicine and surgical and curative devices were to be made available to the public at the cheapest rate. Based on the committee's recommendations, the 1911 Act was amended in 1950 in relation to working of inventions, including compulsory licensing and revocation of patents. In 1952, a further amendment was made to provide for compulsory license in respect of food and medicine, insecticides, germicides and fungicide, and a process for producing substance or any invention relating to surgical and curative devices. A bill known as the Patents Bill 1953 was then introduced in the Lok Sabha, but it lapsed due to the dissolution of the Lok Sabha. It's an irony of fate that whenever a new patents bill was introduced, the Lok Sabha got dissolved. Therefore, the opposition found it the best way of asking for a new patents bill. Therefore, Justice Rajagopal Iyengar was appointed in 1957 to examine and review the patent laws afresh, and he submitted a report in 1959. It will be of interest to note that Justice Iyengar's report specifically discussed issues relating to patents for inventions relating to food and medicine. His report contained details as to how Germany was the first country to adapt the system of confining the patentability of inventions relating to chemical products or substances only to process claims. This law was then followed by Austria, Brazil, Czechoslovakia, Holland, Hungary, Japan, Mexico, Norway, Poland, and USSR. Therefore, Justice Iyengar advocated that insofar as chemical and pharmaceutical industry are concerned, only process claims are to be permitted. On the basis of his report, the Patents Bill 1965 was introduced in the Lok Sabha, which was then referred to the Joint Parliamentary Committee. The Joint Committee adopted some amendments and submitted a report, but as ill luck would have it, the said bill also lapsed after the third Lok Sabha was dissolved in March 1967. The Patents Bill was again introduced in Parliament in 1970 and the Patents Act 1970 came into existence. It was notified only 2 years later on 20th April 1972 in respect of all the provisions except a few. The remaining provisions were notified after a further period of 6 years in 1978. Under the Patents Act of 1970, monopolies were granted only to manufacturing processes and not to the end products themselves. Therefore, it was claimed that companies were able to reverse engineer the production process and manufacture generic version of drugs. The generic copies of drugs were obviously cheaper. Sometimes they were priced at less than 10% of the cost of the patented drug. Generic drugs have always been a big challenge for the established big pharma companies. The Congressional Budget Office estimates that approximately about 802 millions are spent from the stage of discovery to the stage of product launch. In 1976, the estimate was $137 million, but by 1990, it had increased to $445 million. The big pharma companies take advantage of their hard work and investments while patents were in effect. But once the patents expired, the generic drug makers were able to undercut big pharma companies' profit margin within 6 months by producing low cost, in most cases, very effective alternatives. Therefore, pharmaceutical companies in the United States and the European Union put pressure on the WTO, World Trade Organization, for making all developing countries fall in line. But there was a growing concern that access to medical treatment for diseases such as cancer and HIV would become highly restricted. Today, if you look at the statistics, 94% of the drugs patented all over the world are manufactured by companies that are located in 10 top industrialized countries. The records show that more than 80% of pharmaceutical, pharmaceutical, and biotechnological patent applications recorded between 1995 and 2006 were from 6 countries, namely the United States, Japan, Germany, France, United Kingdom, and Switzerland. In an article published in Forbes on 29/4/2013 under the caption, "We the People versus the Pharmaceutical Industry," Bernard Munoz, its contributor, states that the price tag of $100,000 and above are becoming the norm, and that out of 12 cancer drugs approved in 2012, 11 costed more than this $100,000 norm. Take for instance the development of antiretroviral treatment for HIV/AIDS. The average yearly cost of this treatment using patented drugs is about $10,000 to $15,000 per person. But of the population of developing countries, more than 1 billion live under $1 per day. When South Africa enacted a law empowering the government to import cheap alternatives to brand drugs, the manufacturers of generic drugs could do wonders by producing the same drugs at a cost of as little as 6%. Similarly, the Brazilian government started offering free therapy in 1996. Brazil also used the threat of compulsory licensing. When the United States filed a complaint with the World Trade Organization, all the members of the United Nations Human Rights Commission supported the Brazilian resolution asking nations not to deny equal access for all persons to prevent curative or palliative pharmaceutical and medical technologies. In these circumstances, the TRIPS agreement, what you now know as Trade-Related Intellectual Property Rights Agreement, came into force on the 1st of January 1995. As you know, India was one of the founding members of GATT, General Agreement on Tariffs and Trade, which obliged India to subscribe to TRIPS. Under Article 27 of the agreement, patents were made available for any inventions, whether products or processes, in all fields of technology. Therefore, 1/1/1995 is the cutoff date. Up to 1/1/1995, only processes could be patented in India. But after TRIPS forced the law to change and gave a time limit of 10 years for India to fall in line, the product patenting became possible. This interregnum period, the law introduced a procedure known as mailbox procedure, where product applications for patenting products could be filed and kept in abeyance. What happened thereafter was, when India could not pass the law and make it TRIPS compliant, the United States filed a complaint with the World Trade Organization on the ground that there was no patent protection for pharmaceutical and agricultural chemical products in India. The WTO panel found India guilty. India appealed and the appellate body confirmed. Subsequently, the European Union also filed a complaint in August 1998, and the findings recorded in the American case were extended to the European complaint also. In the meantime, the fourth ministerial conference was held in Doha on 14/11/2001, where Doha Declaration on Public Health was adopted. This declaration addressed the deep disquiet of the developing and least developed countries regarding the obligation under TRIPS. In the meantime, by Amendment Act 1999, which came into force with effect from 1/1/1995 retrospectively, yet this transitional facility of mailbox procedure was introduced. 3 years later, the Patents Amendment Act 2002 was passed. Subsequently, in view of the deadline fast approaching, the Amendment Act had to be hurriedly passed with effect from 1/1/2005, and that is how the patent regime took a complete change from 1995 to 2005. Under this new act, which governed all of us today in India, fundamentally the patented product or process should be shown to be an invention involving an inventive step and capable of industrial application to be qualified as a valid patent. 3 things are important to see if a product can be patented or not. One is the existence of a new product or process. Number 2, an inventive step that was involved in the development of the new product or process. And number 3, an industrial application. In legal terminology, these 3 requirements are called novelty, non-obviousness, and utility. Before I come to the cases that the Supreme Court came to decide in recent times, one should understand the background in which patent regime is administered in India. And for a better understanding of that, it is essential for us to know that these 3 things of novelty, non-obviousness, and utility are essential for a pharmaceutical company to establish that a product developed by them is to be recognized as a valid patent. What happened was, after this new regime came, one important thing that all of us should note is the distinction between what an invention is and what a discovery is. All discoveries are not inventions. They made a great discovery, but no patentable invention. Again, a man who discovered that a known machine can produce effects which no one knew could be produced by it before may make a great and useful discovery. But if he does no more, his discovery is not a patentable invention. This is due to the fact that he would not have added anything to the existing knowledge. He must make some addition not only to knowledge but to previously known inventions, and must use his knowledge and ingenuity so as to produce either a new or useful thing or a new method of producing an old thing or result. A very interesting case came up before the Circuit Court in the United States that was filed by a pharmaceutical company called Alza Corporation against another company called Mylan Laboratories. The case concerned the validity of a claim made by the appellant company in respect of a drug which they were already marketing and the question of infringement of the same, the respondent had filed application for the generic version of the once a day extended release formulation of the anti-incontinence drug by name oxybutynin. Oxybutynin was the drug in question. While holding the claim to be invalid, the Court of Appeal said a claimed invention is unpatentable if the differences between it and the prior art are such that the subject matter as a whole would have been obvious at the time the invention was made to a person having ordinary skill in the art. The Court of Appeals further enlisted 4 factual inquiries to be followed, namely the scope and content of prior art, the level of ordinary skill in the prior art, the differences between the claimed invention and what was in existence. Prior art is nothing but what is already known to persons who are skilled in the art. Then objective evidence of non-obviousness. It is in this background that we have to take note of 2 decisions rendered by the Supreme Court of India. One decision, both these decisions changed the entire landscape relating to patent regime insofar as pharmaceutical industry is concerned. One decision upheld the compulsory license of Bayer's cancer drug, Nexavar, that allowed companies to copy a patented drug and produce generic versions in India. The result is that the cost of the drug was brought down from $5,500 to just $175. Even this is not affordable, but still it was brought down. The next decision, about which all of you are familiar, is the decision of the Supreme Court in Novartis. What happened to Novartis was, before I proceed to Novartis, I would like to mention only one thing. The patenting of drugs. One important question relating to patenting of drugs is as to whether a drug is nothing more than an obvious variation of an earlier patented drug or not. In United States itself, a very interesting case came up that was filed by a pharmaceutical giant by name Sanofi Aventis SA, which obtained patent monopoly for their drug called Taxotere. This Taxotere was used to treat prostate cancer. The patent monopoly was granted in 1996. Taxotere used to generate 2.18 billion euros in global sales in 2009. When 2 competing companies by name Hospira Incorporation and Apotex Incorporation attempted to sell the generic version of the drug, Sanofi went to court, but the United States Supreme Court held that 2 of Sanofi's patented drugs are obvious variations of an earlier patent on a drug called docetaxel. Therefore, the price got slashed down to almost about 10%. Coming to what happened in the case of Novartis, a very interesting article was published in Caravan by a lawyer by name Suhrit Parsarthi. He traced the history of this Novartis litigation in this article. It appears that in 1960, university researchers discovered a non-inheritable genetic abnormality in the vast majority of people suffering from what they called chronic myeloid leukemia, CML they say, an aggressive cancer that causes the body to produce excess quantity of white blood cells. Worldwide, nearly 1.5 million people suffer from the disease, and there are an estimated 12,000 to 24,000 new cases in India every year. Over the course of the next quarter century, scientists in the US and Europe, many of them working for public funded institutions, investigated the abnormality and were eventually able to link it and the onset of CML to a single protein. In 1996, 2 researchers by name Brian Drucker and Nick Lydon, who was a scientist working at the European pharmaceutical company that became part of Novartis discovered that the functioning of the protein could be disrupted by a chemical called ST1571, which was later renamed as imatinib. The first trial of imatinib in human subjects was conducted in the US in 1998, the same year that Novartis filed its patent application for Gleevec. The results were astounding. All 31 patients in the trial showed complete remission of their cancer. Eventually, the company gained approval from the US Food and Drug Administration in one of the fastest drug reviews ever to make the drug publicly available. Novartis began to market the drug in the US as Gleevec and internationally as Gleevec. But what happened was, insofar as imatinib was concerned, during the transition period between 1995 to 2005, this company Novartis had obtained exclusive marketing rights in India. Therefore, the manufacturers of the generic version of the drug imatinib were already producing this drug. When, after the regime completely changed, when the application made by Novartis for patenting Gleevec was examined by the patent office, the Indian patent office found the drug to be already known in prior art. It was hit by obviousness. The company appealed to the Intellectual Property Appellate Board, and the Appellate Board reversed two findings but confirmed that under Section 3D of the Patents Act, it was not patentable in India. Instead of approaching the High Court, Novartis straightaway filed an appeal before the Supreme Court. As a case of exception, Supreme Court entertained the appeal directly from the order of the Intellectual Property Appellate Board and ultimately held that this patent is not valid in India. And that decision brought forth relief to millions of patients, cancer patients in India in recent times. That was one decision for which the Supreme Court is still remembered. Therefore, the question is as to whether what was decided in Novartis is what is commonly known as evergreening effect. All of you know that a patent is valid only for a particular period of time. Under the Indian Patents Act, a patent monopoly granted by the government is valid for a period of 20 years. What pharmaceutical companies started doing was to make small alterations, small additions, and then again apply for a fresh patent so that the longevity of the patent is much more than the longevity of the patients. This is what is called evergreening effect. The Supreme Court came down upon this evergreening effect and said these small additions do not qualify for a valid patent under the Indian Patents Act and even under the patent law of any other country. Therefore, what has today happened is, in 2010, a very important development had taken place. That was considered to be a milestone. It led to the formation of Asian Cancer Research Group by three major pharma companies, namely Eli Lilly, Merck & Co. and Pfizer on 23/2/2010. The major objectives of these independent not-for-profit entity, at least that is what they call it, we have to test it. The major objective of these independent not-for-profit entity is to speed up the early stage of research and development and therefore the treatment of patients affected with the most commonly diagnosed in India. At about the same time, in England, a white paper was submitted finding out ways and means as to how different types of patent regimes could be developed for countries which are already developed and countries which are termed as developing countries. Today, people have recognized that you cannot apply the same law that is applied in developed countries to countries where people are not able to pay for even their food bill. Therefore, What is important to understand is that whether today's patent regime serves public good or not, when it comes to public interest concerns, the courts have played a very crucial role in the past, and I suppose they will continue to do the same. With these few words, I thank the organizers for giving me this opportunity to share a few thoughts with you. Thank you very much.
Thank